All right, good afternoon, and welcome to You Have a Trust. Is It Actually Working webinar. My name is Liz Smith, and in a moment, I'll do a bit more of an introduction to myself. So first, just a quick sort of orientation to today's presentation. This is really geared towards, I wanted to reach out to people that might have put a trust together at some point and really gearing towards a revocable trust or a living trust. And I'll talk more about what I mean by those. But gearing towards people that had a trust. And you may be wondering, lots of times I'll meet with clients who have something set up and don't necessarily know how it works or what you need to do to keep up with it. And so I just wanted to see, yeah, try and reach out about a trust. This will be somewhat of an opportunity, at least, to have an interactive presentation. I'm going to talk for a bit and then open it up to questions that you might have. If you are joining us today or listening to the recording and you think, well, I don't have a trust in place, I just wanted to learn about trusts and about planning, this is going to be a great opportunity to do that as well, because you'll really get into the nitty-gritty about trusts more than I would do in a more standard life and legacy planning presentation, which is something that our office does as well. And if you don't have anything set up, I also might recommend that you also attend one of those kind of more foundational presentations, less specific on a trust and what that is. That could be helpful. But I'll also talk about what you might want to do to meet with someone in our office. Yeah, as I'm speaking, Stephanie Devon also just went off video and she's joining us. She has the same background I do, which is great. You can see that she's one of our team members. If you have questions, first of all, while I'm talking, I will be able to, I might be able to see your message in the chat. And actually, like I said, this should be interactive. So feel free to ask questions in the chat. And then if you want to voice your question, I'll ask you to wait until the end for that. But feel free to type in. You can message everyone. If you wanted something specific from our office, you can message Stephanie Devon personally, and we'll talk some more at the end about how to get help from us. So with that kind of introduction to what we're doing here today, to what I want to do is I just give you an introduction to who I am and who we are at 49th Estate Planning. And then I am going to talk a little about probate and what that is, just to give us kind of the framework for what a trust does and why people use trusts. And then I'm going to bring in some props that I have with me. Oh, we'll see on Zoom how well that works. And we'll talk about just a trust and what it means it is, what it does, and what you need to do to make sure that that trust is going to work how you probably want it to upon your death. And then from there, I am going to cover a little bit at the end about incapacity planning because a trust actually helps with that as well, and some of the other tools that you might want in place at that time too. So, okay, just to give a bit of an introduction who I am speaking to you, my name is Liz Smith. I live in Juneau, and I've been there a little over 20 years now. That I moved to Juneau before law school, went out to the East Coast in Vermont to go to school, came back and worked for the state for about 8.5 years after law school, trying to find the job that I loved. I moved around a lot to different positions, and nothing was quite sticking for me and just who I am. I ended up starting a little business on the side, doing health coaching, totally different, but it just actually not that different in some ways. It just made me realize I really liked the creative energy that comes with running a business. Um, Now, at the time, I left the state in 2018, took some time to figure out what was next for me. And at the time, I really did not want to do private practice. I had never had much interest in private practice as a lawyer. At the time in my life, I knew I didn't want to litigate anymore. So I didn't want kind of a general practice. And I just don't like a lot of how a lot about how a traditional law practice is set up. For example, I don't like hiring someone and paying them by the hour. I find that to be frustrating as a client myself, and it's not that much fun either to bill people knowing that, every question you ask, you like have the clock ticking. Um, and so as I was kind of figuring out what to do in my life, I somehow stumbled into estate planning. Someone had mentioned it, and then along the way, I found someone training attorneys to practice estate planning in a way that really resonated with me, and started what was Liz Smith Law in 2019 and changed our name a number of years ago now to really emphasize what we do as estate planning. It's been a really good fit. And our goal has been, first of all, we do everything on a flat fee basis. And that really helps when we talk about trust. Today, we're going to talk about keeping a trust up to date and how that's important. And for us, what we're able to do is have a team involved, be able to charge, what the price will be ahead of time. And then we have a team that can help look at different aspects of incapacity and your death and cover different pieces of that. So part of this talking about trusts, I have a friend whose father paid over $6,000 for his estate plan, and his whole goal was to keep his family out of court and out of conflict with his ex-wife. And then he died, and they were all in court for years, battling with his ex-wife. And my friend just thought, well, what went wrong? What did that attorney do? They must have committed malpractice. And what she learned as she started getting into it was that really it was common. The attorney had prepared the legal paperwork and then probably said, okay, now you go do X, Y, and Z. And then he just never followed through to go do X, Y, and Z. And so when he died, it just wasn't set up properly. So his plan didn't work how he wanted. Um, so that's a bit about us. I'll cover some more at the end. I'm trying to think of yeah, we'll leave it there and we'll talk about trusts. Um, all right. So when we talk about trust, we're talking about passing on assets when someone dies and how to do that. And so if someone dies without a plan in place at all, meaning they don't have a will, they don't have a trust, they just die, it's called intestate. Then the state that they die, that they're resident of, will have a plan for you. And that plan is going to determine who has priority to serve as the administrator to pass assets on and who is going to inherit those assets. So in Alaska, we call the person who would be in charge of the process the personal representative, and the process is probably going to be probate. So you die without a plan, somebody has to navigate this court proceeding, basically a lawsuit, in terms of the steps involved. And once someone is appointed as personal representative, they'll gather your assets and then go through the distribution. So that process of probate is public. Everything that gets filed in court, anyone can run and look at those documents. So usually that would give someone a sense of who is inheriting what. It usually takes 12 to 18 months. That's if everything's going really well. It can take years as well to go through the process of probate. If someone, like all of the natural heirs have to get notified through the probate process. So I guess to allude to that, even if someone has a will, the assets have to go through probate. But if you wanted to disinherit someone, they would still get notified that everything's happening with probate. And then it can cost a lot of money as well to go through the probate process. And so probate is what happens if someone dies with assets in their name and those assets have to get passed on. And whether you have, like I already said it, right? So if you die without a will, or if you die with a will, there would still be probate with some exceptions, but we're going to talk about the main exception today. So out of that, people wanting to avoid that probate process for a variety of reasons, it's become very standard to use something called a revocable trust or a living trust or a revocable living trust. And that has become a tool essentially to bypass probate. So how does that work, right? So we're going to use I'm going to try and do this on video, my little basket here. And we're going to imagine that this is what I've accumulated from my lifetime. And I have little Werther's Originals, right? That seems appropriate to be what I've accumulated during my life. So my house, my car, bank accounts, maybe I have a brokerage account, retirement, life insurance. So my whole little basket of goods. Now, if I just own everything in my name and I continue throughout my life and then I don't have anything in place and I die, then all of these assets, right, that were in my name are going to have to go through that process of probate. So one by one, if I were in a room, I could throw these across the room and you can just imagine that being kind of distributed one by one as they go through the court process. But with a trust, and we'll talk more about the details, with the trust, I would create this trust entity, which I'm going to come back to. But just to get to the point of really what it does, I'm going to put all my assets in the trust so that they're actually owned by the trust and instead of my name. And so then when I die, instead of my loved ones who I will inherit, whoever I want to inherit my Werther's Originals in my basket, I am going to pass this entire basket on to them to inherit rather than having to go through court. It's just kind of a way to keep everything nice and clean and pass on. Okay, so let's talk about the more details, and you can just imagine the basket. So that basket representing a trust. Now, there's lots of kinds of trusts, right? So I'm talking specifically about a trust set up in a specific way, like I said, usually called revocable trust or living trust. So that trust agreement, the basket, gets created by somebody called a grantor. Okay, and I'm going to say that my husband and I are creating this trust together, just to use that as an example. Well, then we would create our basket together. We would both be grantors. And that means that we're going to set up the rules. So that structure of the basket is the rules that are going to govern whatever is in the trust. We are going to also decide what we want into our trust. Now, for a revocable trust, that's going to be probably everything that would otherwise go through probate, meaning our home, our bank accounts, potentially vehicles, not necessarily, maybe a boat, maybe businesses, some of those assets that would otherwise be in our name. We would transfer to the trust. Now, assets in a trust are managed by a trustee. So the trustee is going to make decisions about investing assets within the trust and also distributing to a beneficiary. Initially, just as my husband and I might own bank accounts in our home together, we are going to own our trust together and we're going to hold it mutually, right? So you can imagine us both holding one side of the handle. We're in full control of assets. If we want to sell our house or give money away, we can do that. There's no loss of control with our trust. If we want to dissolve the box, we can even do that. We can change the rules around the box as well. And then, and we're going to be the beneficiaries. So we're holding this for our lifetime. We created this entity and we can make changes. But let's say my husband dies and our trust can establish what happens at that point. Sometimes couples choose that when one dies, there's actually going to be two trusts created. So in that case, he could have said before he died, I want to give my portion, so my assets that I've worked for, to my wife, but I'm going to do so in a different trust. And then when I die, let's say he had kids from a prior relationship, he can say, I'm going to give those assets to my wife. She can use them for her basic living expenses should she need them. But the goal is really going to be to preserve whatever's I've given her to my children, so that when she dies, everything would pass on. So that would have been one option that he could have done. Or when he died, he could have just said, okay, the whole box, everything goes to my wife and she can continue to control and hold on to it, and even have the power to change whoever would inherit when I die and whatever rules are. So then I would move along, right, and hold on to whatever I've inherited, my trust. And then let's say I become incapacitated. Well, now this is still mine. The rules are still the same. I am still the beneficiary during my lifetime. However, upon my incapacity, I will have named someone to be the successor trustee upon my incapacity. So when I'm incapacitated, I am basically handing over the hold to my successor trustee, and they are going to be holding on to those assets, managing them for my benefit while I'm alive. Everything still stays to my benefit. But eventually I will die. And then at that point, actually, when I become incapacitated, the rules of the trust cannot be changed, right? So initially I could make any changes. Upon incapacity, I cannot. So then there's this structure. Once I'm incapacitated, it can't be changed. Once I die, it cannot be changed. And then when I die, the trustee is going to take this and they're going to look at those rules that govern whatever I've set up. And then they are going to distribute out of the trust as they see fit, right? So you have to do it within a reasonable period of time. And so maybe I gave my house to a neighbor. Maybe I gave my retirement to charity, maybe life insurance to charity, what have you, or distributed to children. The trustee would be in charge of following those rules and distributing as I saw fit. So that's the basic structure of the trust and the reason to use this type of revocable trust during my life, because you can imagine giving this whole thing, allowing someone to follow is going to be easier than as long as everything's set up, right? That's why we're here. Going to be much easier than going through the probate process. Um, so I'm going to talk in just a moment about how to make sure it works, right? Which I keep talking about. What do you have to do? What do you have to do? And trying to uh, just make sure that it's going to be ready to have that smooth transition when you die. So I'm going to come to that in just a moment. But first, I also want to talk about what can happen. I talked about when my husband dies, how assets could pass to me. And then when I die, what can happen, right? So there's those options of does everything come to me and I could make changes, or does his portion actually stay in a different trust and I can't make changes? And there's lots of reasons to do that, sometimes for estate tax planning, sometimes just to protect beneficiaries that would come later. But then I also want to talk about trusts that you can use for beneficiaries and how they inherit. So one option is everything in your basket, everything you've acquired during your lifetime just gets distributed outright. You're just handing over the asset to your beneficiary and saying, okay, now you are in control. You can do whatever you want. You can add this to your estate. You can have your own revocable trust. You can have your will. You can give assets to a spouse or your children or charity, whatever you choose. So that's the most standard way that someone would choose distribution, just outright. But you can also use trusts for the inheritance. So just as I said that my husband could give me his own box with some rules that I could benefit from, you can do that to other beneficiaries as well, like your children or grandchildren or however you want to set up. And some reasons that people would choose that other distribution has to do with, let's say you have young children and you're setting up a trust so that if you do die young, they will have some protections, right? So in that case, with young children, the default in Alaska, if you die without a plan, is they would inherit everything. They basically get control of funds at age 18. So maybe you instead want to say they get a portion at age 20, a portion at age 25, and the rest at age 30, or however you want to establish. And so what you're doing in that case, if you die with someone who's young, is you're handing over the reins, you're handing over the control to a successor trustee, and they're going to hold on to the funds for that young child. Now they're going to decide perhaps to support different education, pay for different sports from the funds that you've left. Um, they might pay, yeah, I think I said pay for education, etc. And then whatever age you choose is when you're giving over control. So you might say, okay, at age 25, my child can have anything left. So the trustee might have spent a portion and then everything left would just go outright. And at that point, your child would be able to choose then how to invest and how to spend for their own benefit. Another option that people will choose trusts in order to leave to a trust is not just age related, but how someone chose to live their life. So if you want to leave to someone that has a gambles too much or drinks too much or uses drugs, or you're worried that they could actually harm them, or just don't like how they would spend and you want to have some control, then you can use a trust to do that as well. So in my own family, my mother was an only child. She grew up in California, middle class family, and she started getting involved in drugs and alcohol at a very young age, in high school, and barely graduated high school, but made it through, had me young, continued to work and somewhat, get through life and somewhat productive of a life. When I was in first grade, her parents, my grandparents, passed away, and they left everything to her outright. And she decided it would be a good idea. So outright just means the full, right? They just gave her, do whatever you want with it. And they decided that it would be a good idea. Um, she decided it would be a good idea to just sell everything, move to Oregon. She spent 14 years being completely unproductive in her life, getting into tremendous debt. At the end of that, she was able to work for a short period of time, and then her health was just too poor. And now she's in a nursing home in her early 60s. Um, so there's lots that we can say about that in terms of, well, obviously she had some choice in her own decision making, but it's just a really, really good example of what her parents could have done instead. So instead of just giving her everything, do what you want, they could have given her her own trust. And to hold her own basket, they could have asked a friend to be the trustee or named a corporate trustee. And they would be responsible to make the investment decisions, and then follow the parents' wishes on how to distribute. So, for the rules for what they gifted to their daughter, they could have said, we want her to have a job as long as she's able to work, and set up structure around that. So that if she wasn't working, she wouldn't get any distributions. They could have said, we want to provide housing, but nothing more. They could have said, we don't want her to be using, and here's kind of the structure and what that means, and here's some authority for the trustee to do drug testing or what have you. So they really could have set up whatever rules they wanted for her, and potentially had the funds last longer as well. And then the third reason that people often will create a trust is if I give to so this is someone who, let's say you want to leave to a child who's actually very responsible with funds, and has really their own money that you want to see protected and then have the inheritance protected. So if I just give to my child, here is your inheritance, and they just commingle with their own funds. First of all, let's say I give to my child and they later divorce, but they've put everything into their joint account with their spouse. Well, then the inheritance is ultimately going to be split in that divorce, right? Or if I give to my child, they commingle with their funds and then they get sued in a car accident. They have a problem with professional liability and it exceeds insurance and they have to pay out of their own funds, etc. Then all the inheritance will be subject to any debt like that. However, if I had left my child in a trust, I can even allow my child to be the trustee of the trust, but it can be set up so they can make their own investment decisions and decide how to spend, but I can structure it in such a way where there's some protection there. So that can be geared where if my child later divorced, the assets wouldn't be split. That can be really geared towards solid asset creditor protection if that's your goal. And then you can also set up generational wealth to say, I'm going to give my basket to my child or my multiple children, my descendants. And then when they die, they actually have to leave their basket to their children and to keep assets in the bloodline that way. So those are kind of three reasons that you might not just set up a trust initially, but then also structure your trust to leave assets to children. Okay, so now let's talk about the real meat here and how to take care of your trust over your lifetime. So first, I always recommend having an attorney set up a trust. I think there's a lot that I just have yet to see kind of an online trust that will work the way someone wants them to. And then attorney trusts are very different. I think processes and systems within an office can vary. But attending this webinar, you may have one set up, right? And so that means you have the structure. So what an attorney is going to do for you at bare minimum is going to be create the vessel and set up the rules around the trust. So those rules are going to include who is the successor trustee, who do you want to manage if you're incapacitated, and then where are your assets going to be distributed to. That's the main function. And then there's a lot more that can be into the trust as well. And so that's the structure, right? That's the structure, what you want to happen. But one key point in order for that trust to work, right, is your assets have to be in the trust. If you have your vessel over here and you have a setup and it says what's going to happen, but you still own assets in your name, then this is not going to do a whole lot of good. Now, probably usually when you get a trust, you're also going to get something called a pour over will, right? And so anyway, I'll get to that in just a sec. But so you have your trust, but then you need to get assets into the trust. So what does that mean? If I have a home, I actually need a deed to transfer from my name to the trust. So you can go look at your deed and make sure that's in the trust. If I have a bank account, I actually need to change the title on the bank account to the trust. Now, normally that doesn't mean that you actually have to change your bank account number. It depends on the bank, but usually you don't have to change your number. It's fairly seamless, but you should be seeing your trust name on your bank account. Vehicles I tend not to put in a trust. Brokerage account should be owned by your trust. So basically everything that you own either should have a beneficiary designated or be owned by your trust. Personal property, assets without a title, you should have an assignment as just assigning those assets, to the trust. So that is like the key is having assets in the trust. If you die, let's say you have most things titled to your trust, but you bought a new house. So you did your trust, you got everything into your trust, and then you start aging and you downsize, buy a smaller property, and you hold that property just in your name. So then when you die, that property would have to go through the probate process. If you have a pour over will, which is that backup will, then it would transfer into your trust through that process. But what's really the point of having a trust if everything's not in it? So that's just one key. It's not just making sure you funded initially, and then also keeping that up to date. We meet with all of our clients for free every 3 years, and then also have a client care program for ongoing support, just making sure that things stay up to date because a lot can change in our lives and we don't always think about our trust and kind of what's happening. The other thing that you want to do to make sure that your trust is going to work when you die is simply to look at it regularly and make sure that you still have what you want in place. Are the successor trustees who you want to serve? Now, we usually recommend having 3. So if you're incapacitated, then who would hold the reins and manage assets after you. And then if they can't do it, then another and then another. So sometimes maybe your first in line successor trustee, maybe you named, you did your planning in kind of earlier adulthood, you named a parent, and now they really wouldn't be well suited to do it. Well, they could resign or just be unavailable, and then the next in line could be your successor trustee. So you don't necessarily need to update all the time, but you just want to make sure that you understand what would happen based on life right now. And then also, of course, updating the beneficiaries. So is everything set to pass how you want it to? And you usually have a better chance if those things. I find that clients, kind of know if, oh, do I need to change something? And oftentimes, a well-drafted document really does not need to change a lot. Like if someone passed away, we probably have indicated in the document what's going to happen in result of that. But it's good just to, as things change, have an idea. So those are the main aspects I see that can kind of go wrong with a trust. If you have a trust and then you moved, I always recommend having it looked over by an attorney in the new state. And that's really, it's not necessarily, a good trust should work no matter where you are. But it's a matter of just local policies. Even things like a power of attorney locally might be a good idea. Or in Alaska, we have something called a disposition document. So I would recommend someone moving here has that. But then if you move to another state, what do they have that you might want? And yeah, those are the main aspects of keeping up a trust. And so I'm going to shift and talk about incapacity, and then we'll talk about your next steps and then open it up for questions. So I've really focused on passing assets on and how to do that, which is an important piece. But also important is making sure that you're set up so that if you were unable to manage assets or make your own healthcare decisions, that you have someone to be able to do that for you. One of the real nice things about a trust is that if you are incapacitated, your successor trustee is going to manage trust assets for your benefit, like I mentioned. Now, if you've ever worked or tried to use a power of attorney to make decisions for someone, it can actually be very challenging to work under a power of attorney. And one nice thing about a trust is that anything in the trust upon incapacity is managed by your successor trustee. So they don't need to use the power of attorney. They are going to be named successor trustee. They'll have documentation showing that they're successor trustee. And usually that's easier for them to be able to manage your bank accounts or access a brokerage account to pay any expenses that you need. So that's one benefit of a trust. But in addition to a trust, you still want to have a financial power of attorney. So who's going to make financial decisions for you, as well as a healthcare power of attorney naming who will make healthcare decisions for you. Many people also choose an advance directive or a living will if you want to specify that you don't want to be on continued life support. If you had like a terminal condition, for example. Yeah, I thought I was going to say something else, but oh, I was going to say updating those. So I usually recommend powers of attorney and healthcare directives that you have them updated at least every 6 years. Just it's usually easier to use if whoever's like if it's up to date, basically, if it's relatively new and not like 20 years old, which can lead to more questions. And then that can also is going to incorporate if there's any new laws, having a new document in place. Okay, so that is the foundation. If you are potentially have a plan that someone else did, not potentially, if you have a plan and you're thinking, oh, okay, this is good, I'm going to go look over, and you would like some help looking over your existing trust, we would be happy to do that for you. Our office, just to give you an idea of how we work, we start with something called a life and legacy planning session typically when we meet with new clients. And during that meeting, we ask you to fill out an inventory ahead of time. And then you walk through with an attorney in our office, an overview of you share your family information, and then we talk about what happens now um, under your existing plan, whether that's a plan or no plan, and then you tell us what you like about that. And by scheduling a 2-hour meeting, that's really designed to then design a plan for someone who might not have one in place or knows that they are ready to change it. And so we go forward with that. But if you already have a plan in place and you just want to like look at it, look over it, how does everything set up? We have a plan review meeting that we would love to offer to you. And that plan review, if you have an existing trust, we're going to go through all the different provisions of the trust, getting into a lot more detail than I've covered here. We'll look over the funding, but also just what's in your trust. What does that mean? What are kind of some different options? And from there, you get to decide, is that what I want? Or do I want something different? So if you are interested in a plan review and you have an existing trust, we do typically charge $950 to do a review meeting. We schedule that for 2 hours. So that's enough time to get that thorough review. And then if you did decide you wanted changes, we would move on to designing that. So like I said, normally $950 for attending the presentation today. If you book your plan review meeting today, it can be booked out into the future. I think we're already booking well into March. But we would want that document ahead of time. We also want you to fill out an inventory to give us a sense of the assets you have and are they in the trust or not. And if you book today, we'll give you $250 off that meeting. So that would bring the cost down to $700. If you have a much older trust, we might not charge as much to review, but just plan on 700 if you book today. Otherwise, we can still schedule that meeting. If you book later, it would just be the $950. If you happen to be joining or listing and you don't already have a plan or you have a will, then we would still give you $250 off, but it would be of your plan fee. Or if you have a will, then there may be a cost to review that. So just let us know, and then Stephanie would work with you on if there is a cost if you have a will. And Stephanie will be following up with you if you book. And Stephanie, did we get a link out?
Yes, everyone should have a link in their email to book their trust review. You can also use that form to just book a life and legacy planning session if you don't currently already have a plan in place. I know a couple of people in here do already have their trust review or planning session booked, so you guys are good. You don't need to do anything if it's already scheduled. And other than that, you should all either already have that email or be getting that any minute.
Great. Thank you.